Legal business environment. Module 3, bankruptcy laws. Bankruptcy law responds to the need to solve a basic problem among debtor with creditors when the debts can't be paid. The situation is not being able to face the debts can be due to the lack of liquidity of the debtor despite being solvent at the accounting level, or because the debtor is insolvent, a situation that occurs when assets are lower than liabilities. In these situations, a judicial procedure can be opened and allow all the debts of the debtor to be paid at the same time and jointly before the creditors. This prevents less informed creditors from being harmed in the event that the debt is collected by some of them before others. The judicial process, called par condicio creditorum, equal status of creditors, makes all the creditors subject to the same conditions. The subjection of equality is called par condicio creditorum, equal status of the creditors. Bankruptcy law allows, in addition to certain equalities between the creditors, the maximization of the debtor's wealth, since in the judicial process, the payment possibilities which allow the debtor to continue generating resources to pay the debt and keep managing his or her company are discussed. So, 3.1, we come to the declaration of bankruptcy. Any individual or legal company, or even companies without legal status, which are in a situation of insolvency and cannot regularly comply with the required obligations, can declare bankruptcy. And the requirements are the unsuccessful seizure of property, the general dismissal of payments, the generalized seizure of the assets of the debtor, the asset raising or liquidation, and non-compliance for 3 months with tax, salary, or social security payments. The request for bankruptcy can be carried out by the debtor or the creditor. In the event that the creditor makes the request, we will speak of voluntary administration, while if the request is made by the creditor, it's called necessary administration. The declaration of bankruptcy must be state the information necessary to provide insolvency, and the judge will hear the parties once they have verified that the legal requirements are met. If the administration is accepted and declared, it will be registered in the public bankruptcy registry, as well as the civil, commercial, and property registers according to the type of person, company that has been declared bankrupt. Now we come to the bankruptcy administration. There are 3 members of the bankruptcy administration appointed by the judge at the time of the declaration of insolvency. These are a practicing lawyer with a minimum of 5 years experience, an economist, accountant, auditor, or business title holder with a minimum of 5 years experience, an ordinary creditor, or a creditor with a general privilege. The election of the 3 professionals can be by lot or by the judge. They are selected from a list that professional association provide to the judge annually with the members that meet the necessary requirements. Article 28 of the Bankruptcy Law, whose last revision came in force on the 1st of January 2016, includes the following incapacities that prevent someone from being appointed insolvency administration. This would make it impossible for you to be. That would be if you cannot be administrators for the SA company or private limited company, those who cannot be administrators, those who have provided any kind of professional services to the debtor or person notably related to them in the last 3 years, including those who, during that period of time, have shared with him or her the pursuit of professional activities of the same or different type. And those who, being enrolled in the 4th section of the Public Bankruptcy Registry, are in any of the situations referred to in Article 13 of the Royal Legislative Decree on July 1st of 2011, by which the consolidated text of the accounts auditing law was approved, in relationship to the debtor, his or her directors or administrators, or to a creditor that represents more than 10% of the passive assets of the debtor. Then we come to those who are especially related to someone who has provided any kind of professional service to the debtor or to a person related to him or her in the last 3 years. Persons who have been appointed to the said office by the same court in 3 administrations within the previous 2 years, and for this purpose, the appointments made in the administration of the company belonging to the same group of the companies will be counted as one. Those who have been separated from this position within the previous 3 years, or those who have been disqualified by the final judgment of disapproval of accounts in previous competitions, and those except for legal entities registered in the 4th section of the Public Bankruptcy Registry. Bankruptcy administrators may not be appointed in the same administration if they have any links with it. A bankruptcy administrator cannot be someone who, as an independent expert, has issued a report related to the refinancing agreement that the debtor had reached before his or her declaration of bankruptcy. Now, here are the functions of the bankruptcy administrators set out by Article 33 of the Bankruptcy Law. From a procedural point of view, they're taking action against the partner or partners personally responsible for the debt prior to the declaration of bankruptcy, exercising the liability actions of the bankrupt person against administration, auditors, or liquidators, requesting where appropriate the seizure of assets and rights of the administrators, liquidators, de facto or de jure, general attorneys, and those who have had this condition within 2 years prior to the date of declaration of the administration, as well as of their partners personally responsible for the debts of the company prior to the declaration of bankruptcy. Requesting where appropriate, the removal and cancellation of embargoes where the conditions of them severely hamper the continuing continuity of the professional or business activity of the bankrupt person. An exception would be in administrative embargoes which cannot be removed or cancelled. Setting aside the eviction action against the debtor prior to the declaration of bankruptcy, as well as to rehabilitate the validity of the lease contract till the moment when the actual eviction is carried out. Exercising determination and actions, requesting the execution of the sentence in the event that the judge has condemned administrators, attorneys, or partners to cover the deficit. Requesting the transformation of the abbreviated procedure into an ordinary one, or an ordinary procedure into an abbreviated one. Replacing the debtor in the legal proceedings in process, and exercising non-personal actions. Characteristics of the debtor or the administrative body. Carrying out until the judge approval of the agreement or the opening of the liquidation phase the disposition that is deemed necessary to guarantee the viability of the company or the treasury needs that the administration demands. Attending the professional associations of the bankrupt person, carrying out depositions and disposition acts that are not necessarily for the continuity of the activity when offers that substantially match the value given to them in inventory are made. Petitioning the judge to revoke appointment of the auditor and appoint another to verify the annual accounts. Assuming after judicial attribution the performance of the political rights of the debtor and other entities, claiming the disbursement of the social contributions that have been deferred, rehabilitating loan contracts and other credit in favor for which the due date of payment or of amortization or accrued interest has passed within the 3 months preceding the declaration of the insolvency. Rehabilitating contracts for the acquisition of movable and immovable property with consideration or deferred price, whose resolution has occurred within 3 months preceding the declaration of insolvency. Requesting authorization so that the disqualified administrator can continue to be in charge of the company. Calling the general board meeting or assembly of partners for the appointment of those who fill the vacancies of the disqualified. Granting the debtor the ability to file claims or appeals, settle compromise, or desist with the litigious matter may affect their assets except in actions of a non-personal nature. If needed in the bankruptcy proceeding, substituting the management powers and disposition of the patrimony of the debtor in accordance with the provisions of Article 40.2, and in particular adopting the necessary measures for the continuation of the professional or business activity, formulating and auditing the annual accounts, applying to the judge to terminate contracts where both parties have reciprocal obligation to fulfill if deemed appropriate to the interest of the administration, and the submission of tax declarations and self-assessments. Number 13, in the voluntary administration, intervening the powers of administration and provision of the debtor's assets in accordance with provisions of Article 40.1, and in particular supervising the formulation of the accounts. Determining the acts or operations specific to the line of business or traffic that, because they are necessary for the continuity of the activity, are authorized in a general manner. Authorizing or confirming the act of administration and disposition of the administrative body, granting the debtor the authorization to withdraw, totally or partially, and to settle the litigation where the litigious matter may affect his or her assets, authorizing the filing of claims, submitting declarations, and tax self-assessments. Now, in work matters, one is the same group, executing the judicial decisions which would match the date of the declaration of bankruptcy on files of substantial modification of the conditions of collective work. And requesting from the judge of the bankruptcy the significant modification of the working conditions and the collective termination or suspension of the work contract in which the bankrupt person is the employer. Intervene the files on significant modification of the collective work conditions initiated during the bankruptcy proceeding, and when appropriate, agreeing to the representatives of the workers in their condition. Extinguishing or suspending the contracts of the debtor with senior management personnel. Asking the judge to postpone the payment of compensation derived from senior management contracts until the judgment is final. Relating to the rights of the creditor, modifying the order of payment of the loans where considered convenient, preparing the list of creditors, determining the inclusion or exclusion of the list of creditors of the credits revealed in the procedure, resolving the inclusion of new loans in the list of final creditors before the approval of the proposed agreement, and requesting the opening of the liquidation phase in case of cessation of professional or business activity. Number 4, communicating to the holder of the loans with special privilege the will to execute their payment generated from the bankruptcy activity without affecting their assets or liabilities, reimbursing them in the method that they used in the loan, and asking the judge to keep the taxes in case of sale of goods subject to special privilege. requesting the judge to make regular payments of credits in advance when he or she continues the payments of the credits against the estate or the privileged creditors sufficiently covered. Now, coming to reports and evaluation functions, they're presenting the report to the judge, making the inventory of the active assets, asking the judge to appoint independent experts, evaluating the content of the anticipated agreement proposal, making the list of final creditors and inventory, evaluating the contents of the agreement in relationship to the payment plans and its viability plan, and reporting on the sales of the debtor's company, submitting to the judge quarterly reports on the status of settlement options, and final report justifying the operations performed on the settlement, in the settlement. Number 9, presenting to the judge a reasoned and documented report on the relevant facts for the qualification of the administration, with proposals of resolution of guilty or incidental administrations. Reporting before the judge, deciding to conclude the bankruptcy, for the payment of all credits or the resignation of all the recognized creditors, updating the inventory and the list of creditors trained in the procedure in the event of a reopening, and value and creation and settlement functions while they replace the administrators or liquidators when the liquidation phase opens, presenting to the judge a liquidation plan for the realization of the assets and rights integrated in the active assets of the administration, and requesting from the judge the direct sale of assets subject to special privilege. Now we come to the secretarial functions. Electronic communications of the bank, declaration to the state agent of the tax administration and general treasury of the Social Security, communicating to the creditors the declaration of bankruptcy and obligations to communicate their credits, communicating to the creditors a list of provisional creditors. Number 4, receiving credit communications from the creditors, assisting the secretary of the court in the meeting of creditors on sharing in when the judge decides so, attending the creditors meeting, reporting the bankruptcy declaration to no creditors who have their residence, domicile, and headquarters abroad, requesting the bankruptcy declarations relevant to advertising abroad and other acts of the procedure when it suits the interest of the administrator, requiring the translation of the credit communications writing of foreign creditors into Spanish, carrying out the remote communications provided by the law, and any others than this and other laws attribute to them. Now, here's the effects of the bankruptcy declaration of the debtor. In the case of voluntary bankruptcy, the debtor retains the power of administration and disposition of his or her assets, providing that the bankruptcy administrators give their authority or compliance. In the case of necessary administration, the powers of administration and disposition of the debtor's assets will be suspended and replaced by the bankruptcy administrators. Effects of the bankruptcy declaration on creditors. Once the bankruptcy is declared, one of the most important effects of the bankruptcy declaration is the fact that the possibility of taking legal action to collect debts disappears and the pending actions are suspended. All the creditors of the debtor, ordinary or not, are integrated into the liabilities of the administration. In the event that the person brought into the administration is married in a joint ownership property system, the loans against the spouse of the insolvent party are included in the liabilities, which are also loans under the responsibility of the conjugal community. In Article 56 of the bankruptcy law, it is recognized that the creditors who have guarantee in assets of the bankrupt person that are necessary for the continuity of the professional or business activities may not initiate the enforcement of the real guarantee until an agreement is approved. The content does not affect this exercise of this right or 1 year after the declaration of insolvency without the opening of the liquidation phase. In particular, the shares of or participation of companies intended exclusively for the holding of the asset, and the necessary liabilities for their financing are not considered necessary for the continuation of an activity, providing that the execution of the guarantees constituted therein do not involve a case of revolution or modification of the contractual agreements that allow the bankrupt person to maintain exploitation of the assets. LB, Part 3, Mod 2. Right. Effects of the bankruptcy declaration on contracts. In the case of contracts, those that are for employment can be rescinded, collective dismissal or work conditions can be substantially modified, reduction of working hours, flexible hours, reduction of salaries, etc. As for contracts pending execution at the time of the administration's declare, they will remain in force. in the contracts entered into by the debtor when at the time of the declaration of bankruptcy one of the parties has fully complied with its obligations and the other party was still in full or partial compliance with the reciprocal obligations, the credit or debit debt correspondence to the debtor will be included as an appropriate in the active estate or in the liabilities of the tender. However, the bankruptcy administration in the case of suspension or the insolvency of person in the case of the intervention may request determination of the contract if they deem it convenient to the interest of the administration. A statement of assets and bankruptcies. Let's make this a little bit wider, if we can, or maybe not. That's better, yes. After the declaration of bankruptcy phase in the bankruptcy process, assets and liabilities have to be determined in order to assess the situation with the family, the company. The assets of the administration are constituted by the assets and the rights integrated in the debtor's wealth on the date of the declaration of bankruptcy, and those assets are reinstated or acquired until the conclusion of the procedure. The assets will be inventoried to be valued, excluding the non-sizable assets that cannot be part of it. In case of conjugal assets, the assets will include the assets and rights of the bankrupt person. Article 77 of the bankruptcy law includes in reference to conjugal assets that if the economic system of the marriage is a joint partnership, it will be included in the liabilities and assets. In addition, common benefits or common property must be used to respond to obligations of the insolvent person. And in this case, the spouse of the insolvent may request the dissolution of the partnership, and the judge will decide on the liquidation or division of the patrimony that will be carried out in a coordinated manner, which results from the agreement or the liquidation of the administration. Statement of liabilities in the bankruptcy. To determine the liabilities of the administration, it is necessary to differentiate bankruptcy loans and the loans against the estate. All the creditors that at the date of the bankruptcy application appear on the list of creditors that have joined the bankruptcy administration report will be part of the general loans. The loans are those that are called by the creditors meeting and participate in the liquidation phase with the loans against the estate are those that arise from the expenses or obligations contracted by the debtor. The bankruptcy administration has to draw up a list of loans, which, unless claimed by the creditor or the third party, is determined final. To prepare the list of loans, a loan communication period has to be opened in which creditors can present their loans and the necessary documents to demonstrate their amount, existence, or classification. In this list, the loans according to 1991 and 92 of the bankruptcy law will be classified as the special privilege loans, and these loans secured by voluntary or legal mortgage, real estate or chattel mortgage, or by non-dispossessory pledge over the assets or rights mortgaged or pledged. The special privilege loan include guaranteed loans with anti-crisis or on the fruits of the taxed property. Second here, bud. And just in case you're interested, this is what antichresis is. Yeah, learned a new word. A legal agreement where a debtor gives a creditor the right to use the property in exchange for the creditor for giving interest or a part of the loan. The debtor keeps ownership of the property. Just so you'd like to know. Okay. Okay, where were we with our antichresis? Yeah, guaranteed loans with antichresis are on the fruits of the tax property. For fixed asset loans, including the workers' loans as long as they are owned or in possession of the debtor, credits of lease payments or sale purchase items termed with deferred price of movable or immovable objects in favor of the lessors or sellers and of the financiers on the leased or sold goods with reservation of ownership with prohibition to dispose of or with subsequent condition in case of non-payment. Loans with security guarantees represented by book entries on the tax value. A loan secured by a pledge constituted in a public document on assets or rights pledged in possession of the creditor or the third party. If it were a pledge of credits, it will suffice that it was recorded in the document with the reliable dates to enjoy privilege over the pledged credits. The pledge of guarantee future loans will only attribute special privilege to the loan before the declaration of bankruptcy, as well as to the loans taken after said declaration. When in compliance with Article 68, it is proceeded to be rehabilitation or when the pledge was registered in a public record prior to the declaration of bankruptcy. And then loans with general privilege, loans for wages that have not been recognized as special privileges in the amount resulting from multiplying 3 times the minimum interprofessional salary by the number of days of salary pending payment, the compensation derived from the termination of the contracts in the amount corresponding to the legal minimum calculated on a basis that does not exceed 3 times the minimum wage, and the compensation derived from work accidents and occupational diseases accrued prior to the declaration of bankruptcy. Equal privilege will hold the national insurance cost capital for which the bankrupt person is legally responsible, and These surcharges on the benefits for breach of the obligations in matters of occupational health, as long as they are accrued prior to the declaration of bankruptcy. The amounts corresponding to tax withholdings and national insurance due to the bankrupt person, due by the bankrupt person in compliance with the legal obligations, the loans of natural persons derived from non-dependent personal work, and those corresponding to the author for the exploitation rights of the work, subject to intellectual property accrued during 6 months prior to the declaration of bankruptcy, tax loans and other public law loans, such as Social Security loans, that do not benefit from special privileges pursuant to Section 1, nor the general privilege of Number 2. The privilege may be exercised for all the credits of the public treasury and for all the Social Security loans, respectively, up to 50% of the amounts. Loans for non-contractual civil liabilities. Loans involving new Treasury revenues granted in the framework of refinancing agreements that meets the conditions set forth in Article 71.6 and in the amount not recognized as a credit against the estate. And claims held by the debtors at the request of which the bankruptcy proceedings have been declared and which are not subordinate will be claimed as up to 50% of their amounts. Subordinated loans. The loans that have been notified late are included by the bankruptcy administration in the list of creditors, as well as those that are not having been notified or having been late are included in the said price of the late notice or by the judge when deciding on the rebuttal. The loans that, by contractual obligation agreement, have the character of subordinates with respect to all the other loans of the debtor. Loans for surcharges and interest of any kind, including moratoriums, except for corresponding to loans with real guarantees to the extent that the respective guarantee reaches, and loans for fines or other, these are called subordinated loans, or other financial penalties. The loans held by some of the persons linked in particular to the debtor, loans that, as a consequence of bankruptcy recidivism, result in favor of whom in the bankruptcy procedure has been declared in bad faith. Bankruptcy recidivism. Okay. Oh, there's another new word for you. Recidivism, the revocation, cancellation, or repeal of a law, order, or agreement. The plaintiff agreed to the recidivism of the agreement. Okay, well, there you are. There you have it. Yeah, I think it was in here somewhere. Oh, yeah, here it is. Bankruptcy recidivism result in favor of whom in the bankruptcy proceedings had been declared in bad faith. The loans derived from the contract. These are all called something. That was what they're called again. Subordinated loans. Right on. Yeah. The loans derived from the contract with reciprocal obligations when the judge ascertains on the basis of insolvency reports that the creditor repeatedly hinders the fulfillment of the contract with the prejudice to the interest of the bankruptcy. Reports on the bankruptcy administration. In the report of bankruptcy administration, the situation of the bankruptcy state is determined, and the report must contain the analysis of data presented by the debtor, the status of the debtor's account and his or her assets, the record of actions and decisions of the insolvency administration, and the inventory of the active estate and the list of creditors. The report must be published in the public bankruptcy registry and posted on the notice board of the court. The bankruptcy solutions. Phases of the agreement. The agreement phase is one of the possible ways to solve the bankruptcy process. All of the above processes are common to the insolvency proceedings. However, once the bankruptcy administration reports are obtained, it can be decided based on the debtor's equity situation, which is the next step to follow, opt for agreement or liquidation. And the law, by default, opts for agreement, as it is considered that the situation is reversible, because in the case of choosing to liquidate, the possibility of agreeing disappears. And there are several limitations regarding the content of the agreement regulated in Article 100. You cannot alter the credit ratings. You cannot propose the transfer of assets and rights to creditors in payment. Regarding the ordinary loans, the withdrawal proposals may not exceed half of the amount of each one of the credits, and awaiting proposals may not exceed 5 years. During the agreement phase, there are agreements of two types: advance agreements, and these are the ones who are quick ways to end the creditor's administrations. Debt can submit to the judge an advance proposal agreement as long as the liquidation has not been requested. And in order to present the proposed upfront agreement, the debtor must not be affected by the following prohibition set out in Article 105. Must not be affected by having been convicted in a final judgment for an offense against the patrimony, socioeconomic order, public tragedy, natural health system, document falsification, or against the rights of workers. And in the event that the debtor is a legal entity, this cause of prohibition will be given in any of its administrators and liquidators have been convicted of any of these crimes, or of those who have been convicted in the 3 years prior to the presentation of the proposal agreement. Also, having failed to in any of the last 3 years the obligation to deposit the annual accounts. In order for the proposal for the advance agreement to be admitted, it must be accompanied by the creditor's adhesion to an income of any kind whose loans exceed 1/5 of the debtor's liability. Once the proposal is presented, the bankruptcy administrators must prepare a report on the viability of the proposal. After the common phase of the process, the judge will check that the accessions formulated in the initials that endorse the proposal meet the necessary majority and will approve of it. Here now is the ordinary agreement. During the agreement phase, proposals can be submitted by the debtors and creditors that represent 1/5 of the liabilities. Both have 40 days before the administration board meeting to present their proposals. The bankruptcy administration will be responsible for preparing a report on each of the proposals submitted. In the event that no proposals are made, the judge will open the liquidation phase. The agreement approved, and I'm pretty sure that was the next sentence. The administration board meeting may be challenged by the bankruptcy administrators or the creditors who do not vote in favor during the meeting. Once the challenge has been resolved, the judge must proceed to approve the agreement. Now here's the effects of the agreement. The agreement will become effective from the date of the sentence that approves it, unless the judge, by reason of the context of the agreement, agrees ex officio or at the request of a party to delay the effectiveness on the date on which the approval reaches finality. In deciding on the delay of the effectiveness of the agreement, the judge may agree on a partial basis. From the effectiveness of the agreement, all the effects of the declaration of bankruptcy will terminate, being replaced by those that are established in the agreement itself, except the duties of collaboration and information that will exist till the conclusion of the procedure. Now we come to the settlement phase. Another way to terminate the process of the administration is liquidation. The liquidation may be requested by the debtor at any time. Within 10 days following the request of the judge will dictate the order opening the liquidation phase. It is considered appropriate to proceed ex officio to the opening of the liquidation phase if requested by the debtor, and none of the proposals presented is approved in the agreement phase, and the agreement reached is breached. The situation of the insolvent person during the liquidation phase will be that of a suspension of his or her powers as administrator and disposition over his or her patrimony. The opening of the settlement will produce an early expiration of the deferred loans and the conversion into money of those that are considered of other benefits. Within 15 days following the notification of the resolution to open the liquidation phase, the insolvency administrator will present to the judge a plan for the liquidation of the assets and rights integrated into the active mass of the contents. The procedure, I think we're on the final page, the process, whenever feasible, must contemplate the unitary disposition of all the asset, establishment, farms, and other productive units of goods and service of the bankrupt person or some of them. The payment of loans will be made according to their classification. First, the assets with real guarantees will be sold, and the creditors with special privilege will be paid. If there is any surplus, then they will be added to the liabilities and assets. As goods are sold, they are used to pay the privileged, ordinary, and subordinate creditors. Every 3 months, starting at the opening of the liquidation phase, the insolvency administration will present to the judge the administration a report on the status of the operation, which will detail and quantify the loans against the accrued and pending payments with indications of its due date. The report will be presented to the judicial office.